You've been asked a lot of questions about abortion, and you've said that Roe v. Wade is settled law. Where are we today? What is the settled law in America about abortion?
I can speak to what the court has said in its precedent. In Planned Parenthood versus Casey, the court reaffirmed the core holding of Roe versus Wade that a woman has a constitutional right to terminate her pregnancy in certain circumstances. In Casey, the court announced that in reviewing state regulations that may apply to that right, that the court considers whether that regulation has an undue burden on the woman's constitutional right. That is my understanding of what the state of the law is.
Let me give you a couple of cases. Let's say I'm 38 weeks pregnant and we discover a small spina bifida sac on the lower sacrum, the lower part of the back on my baby, and I feel like I just can't handle a child with that. Would it be legal in this country to terminate that child's life?
I can't answer that question in the abstract because I would have to look at what the state of the state's law was on that question and what the state said with respect to that issue. I can say that the question of the number of weeks that a woman is pregnant has been, that approach to looking at a woman's act was changed by Casey. The question is the state regulation regulating what a woman does an undue burden? And so I can't answer your hypothetical because I can't look at it as an abstract without knowing what state laws exist on this issue or not. And even if I knew that, I probably couldn't opine because I'm sure that situation might well arise before the court.
Okay. Well, does technology, in terms of the advancement of technology, should it have any bearing whatsoever on the way we look at Roe v. Wade? For example, published reports most recently of a 21-week, it's 142 days, fetus alive and well now at 9 months of age with no apparent complications because the technology has advanced so far that we can now save children who are born prematurely at that level. Should that have any bearing as we look at the law?
The law has answered a different question. It's talked about the constitutional right of women in certain circumstances, and as I indicated, the issue becomes one of what's the state regulation in any particular
I understand,
circumstance.
but all I'm asking is, should it have any bearing?
I can't answer that in the abstract because the question, as it would come before me, wouldn't be in the way that you form it as a citizen. It would come to me as a judge in the context of some action that someone's taking, whether if it's the state, if it's a private citizen being controlled by the state, challenging that action. Those issues are
But viability is a portion of a lot of that. And a lot of the decisions have been made based on viability. If we now have viability at 21 weeks, why would that not be something that should be considered as we look at the status of what can and cannot happen in terms of this right to privacy that's been granted under Roe v. Wade and Casey?
All I can say to you is what the court's done. And the standard that the court has applied, what factors it may or may not look at within a particular factual situation, can't be predicted in a way to say, yes, absolutely, that's going to be considered. No, this won't be considered.
All I'm asking is whether it should. Should viability, should technology at any time be considered as we discuss these very delicate issues that have such an impact on so many people? And your answer is you can't answer it.
I can't because that's not a question that the court reaches out to answer.
Well,
that's a question that gets created by a state regulation of some sort or an action by the state that may or may not, according to some claimant, place an undue burden on her. We don't make policy choices in the court. We look at the case before us with the interests that are argued by the parties, look at our precedent, and try to apply its principles to the arguments parties are raising.
I'm reminded of one of your quotes that says you do make policy, and I won't continue that. I'm concerned, and I think many others are, does a state legislature have the right under the Constitution to determine what is death? Have we statutorily defined, and we have in 50 states and most of the territories, what is the definition of death? You think that's within the realm of the Constitution that states can do that?
Depends on what they're applying that definition to. And so there are situations in which they might, and situations where that definition would or would not have applicability to the dispute before the court. All state action is looked at within the context of what the state is attempting to do and what liabilities it's imposing.
But you would not deny the fact that the states do have the right to set up statutes that define, to give guidance to their citizen what constitutes death.
As I said, it depends on in what context they're attempting to do that.
They're doing it so they limit the liability of others with regard to that decision, which would inherently be the right of a state legislature as I read the Constitution. You may have a different response to that. And which brings me back to technology again. As recently as 6 months ago, we now record fetal heartbeats at 14 days post-conception. We record fetal brainwaves at 39 days post-conception. And I don't expect you to answer this, but I do expect you to pay attention to it as you contemplate these big issues, is we have this schizophrenic rule of the law where we have defined death as the absence of those, but we refuse to define life as the presence of those. And all of us are dependent at different levels on other people during all stages of our development, from the very early in the womb, outside of the womb, to the very late. And it concerns me that we are so inaccurate, or inaccurat's an improper term, inconsistent in terms of our application of logic.